Law. Gary is a San Diego financial solutions attorney, protecting people like you. The Word on Wealth team of financial experts is here to answer your questions and help preserve your family's financial future. Now, here's Gary.
You're live.
Happy. No, what day is it? Is it Thursday?
I have just carried the 5 double by 4. Today is Happy Thursday, Gary.
Everyone. Thank you very much for being along. This is so good. If you notice if you're watching on YouTube, which I know some of you do, which is, watching radio is just one of those things, I guess, that we do. You can see me on YouTube live, and you're going to wonder, well, gosh, why is Gary sitting on the coast of Hawaii? I'm actually doing that electronically and fantasizing that that's where I am. So I'm going to change it now, and I'll be changing it every break. So now I'm in, where am I now? Grand Canyon. There we go.
You can go anywhere in the world.
Well, pretty much. I always stick to pictures that I have taken. So that restricts me to my travels. I mean, I've traveled quite a bit. My Cheryl and I have been married for 42 years. So every once in a while we do a big trip, and so we got some big trips under our belt, which have been a lot of fun. So I always I have them running in my lobby. People come in and see me. They go, "Are those pictures? Are those your vacations and travels?" I said, "Yep, those are all the pictures I've ever taken. Ever since I've had a digital camera, I've taken pictures, and I just run them in my lobby. Anytime there's a picture with no people in it, that's what I put in my lobby." So it's pretty cool. Welcome, everybody, to the Word on Wealth. The lines are open. We're going to open our lines so that we can have you call and participate, and I can answer your questions about estate planning, wills, trusts, power of attorneys, probate, trust administration, how to be a successor trustee, how to be a good one, how not to be a bad one. And you can call 888-344-1170, 888-344-1170. Ask me those questions, and I am so happy to answer. A couple of things we're going to do today is I have come up with a number of questions that I have been asked recently by some of my clients. And I figured that I would go through some of these some of them are a little challenging to talk about on the air just because of the complexity, but it'll be fun, and we'll make it as good as possible so that we can, you guys can learn a little bit more about estate planning. Like, my big thing is do estate planning. And then my bigger thing is teaching you why you should do estate planning. I think that's we're kind of on the why should you do it thing today. So, I want you to do it. Not just because that's how I make my living, but just because it's super important. And
what would you say, Gary? Because I know that I've seen them. I'm sure other people have seen them too, and they make it seem so simple. What would you say? We've talked about it on the show before. When you see, hey, you could do it yourself. Go to this website, download it. It's easy. It's a lot cheaper, but that can really lead to some problems.
Well, cheaper is an interesting definition, Noah, because cheaper meaning you don't have to fork out as much cash to get it done initially, but then cheaper for who? And what I run into when I review a lot of self-done trusts, and I'm not like a jerk about it, but I'll look at them and ask questions like, so let me tell you what your trust says. And I'll go through and I'll say, okay, this is what your trust says. It says that this person is the trustee, and so is this person. And looks like you have your 4 children as co-trustees. Is that what you intended? Yes. Okay, let's talk about the issues with co-trustees. And they go, oh, bad idea, huh? Bad idea, but we can amend it. You can fix it. And then I'll go through and say, okay, now here's what's going to happen when the first one of you dies. Here's what happens to your property. When the second one of you dies, here's what happens. And oops, there's no contingency in here for if you both die together, and we can't tell who dies first. We need to amend that. And I'll go through different things like that. I'll go through things because the downloaded trust, you don't know. I mean, nobody's taking responsibility for getting them right. And kind of here's my thing. In fact, Noah, to answer that question, let me, I have this thing that I call a story that I call the parable of the countertop. And my dad he was very industrious. He was very creative. He was an engineer. He built tools. I mean, he worked for Rohr for a while. So he was like in the aerospace engineer division. He was doing, some basic engineering and created all these different parts that you use to make parts. And he has to create the tools. So he made tools and stuff. And then he became an estimation supervisor. And then he went to law school and became an attorney. So he was a really creative guy. And we did a lot of stuff on our on our own because we didn't have a lot of money. We just had a lot of creativity. And I remember working with my dad and putting together some cabinets. So we bought the wood, made the cabinets. We had some tools out in the garage. Some we had made machines to, do, rabbiting and stuff like that. So we made the doors and the cabinets. And I remember put in the cabinet, and then we were going to put a countertop. We were going to use this material called corian. And it's a really hard plastic type material that you buy, and it looks like stone. And the way you cut it, and you use a router and you machine it and do all this stuff. So you can do it yourself if you wanted to. So I was excited. We put in the cabinets and we were going to do the corian. And my dad said, no, we're not going to do the corian. I said, well, Dad, why don't we? Let's just go buy a sheet of corian, and then we can cut it out. You cut out the sink and the holes for the faucet and all that stuff. And he said, because if we buy the corian, that will be the most expensive material that we get on this whole project. In fact, it'll probably cost more than all the other wood. So if we buy that corian piece and we bring it home and we mess it up,
2 minutes.
we get to go back to the store and buy another piece of corian and try it again. He says, if we hire an expert, then they're going to get it right. They're going to make it look better because they're just good at that. This is what's going to really show. It's going to what's going to really make a difference. And if they break it or do it wrong, they go back to the store, they buy another piece of corian, and they try it again. And if they break it, they do it again. And we only have to pay that one time. So I thought that for me was a really interesting lesson in do it yourself, because we were very much do it yourselfers. But then where it really mattered, it wasn't worth it to do it yourself, because that's where if you mess it up, there's a big penalty. I feel that way with estate planning. Okay. If I do your estate plan as an attorney, and I mess it up, I pay a small fortune every year to an insurance company to ensure that I do things right. And if I mess them up, then my insurance company will cover claims of things that I messed up. So if I mess it up, I do it over. Okay. If I completely mess it up and it costs somebody money, then my insurance company pays. So part of it is almost, you have this insurable guarantee or warranty that it's going to be done right. And if it's messed up, then there's going to be a way to cover the goof up. So I think the big thing with estate planning is if you get it wrong, the penalties for getting it wrong are just enormous. And that goes back on your family. It's not that you end up paying this big penalty. It's that your family does, because when your living trust is doing its thing, you're going to be either incapacitated or you will have passed away. So if you've passed away and the trust is messed up, then it's very expensive to fix, but somebody's got to do it. So I just think that's one of those things where I just believe it's not fair to your family. You're trying to set up an estate plan so your family can be taken care of, and do it right. Don't mess them up. We'll be back on the Word on Wealth with lines open. We'll be back in just a moment.
You've got questions. We've got answers. This is the Word on Wealth with Gary Quackenbush of GQ Law. Gary's here to give you peace of mind with expert estate planning, trust administration, inheritance, and probate. Call Gary to build, protect, and transfer your wealth. 855-500-TRUST. GQlaw.com. You're saving and investing for the future, and that's good. Have you ever stopped to think, where does my money actually go? This is Faith-Based Investing with Anthony Wright.
Most Christian families don't understand this one thing. The money that you're saving for retirement helps fund the abortion industry as well as other liberal anti-family causes. It's the sad, dirty little secret of American investing world. And here's the good news, though. You probably also didn't know that just a few minutes of your time and we'll screen and clean your investments for you. There's no cost, no obligation. Learn the truth about your own investment mix. Then the choice is yours. Remember, the word says when God's money is in the hands of the righteous, the people rejoice. Well, we also are fiduciary investment advisor representatives. That means that our firm makes a pledge to always act in your best interest. Go to BibleSafeInvesting.com. Download a free copy of my book, Faith-Based Investing, or call me at 931-RETIRED. And please don't forget, listen to Faith-Based Investing this weekend right here on Family Talk.
Gary, our listeners are asking about trust disputes and whether or not they'll actually get the inheritance they're expecting.
I think that's a scary thing for most people, because they feel like, if I ask my successor trustee, hey, where's my inheritance? You kind of feel like, oh my gosh, I'm being like rude or whatever, inconsiderate. But I'm telling you, if time goes on, if it's been like 60 days, 90 days, 120 days, that's too long to have heard nothing. You're supposed to hear fairly soon, like within a couple of months after someone's passed, you should be hearing from that successor trustee. And if you're not, I think there's an issue we need to address. So it's not like we're going to go screaming in there, filing lawsuits. We kind of use gentle nudges like, hey, do you know what you're doing? Successor trustee, we kind of want to help you do your job, and we help beneficiaries kind of get things straightened out.
Call or click to request your free initial consultation. GQLaw.com, 855-500-TRUST, GQLaw.com.
Who will you trust with the biggest financial decision of your lifetime? If you're planning to buy or sell a home in San Diego County, do what I do and work with the true San Diego real estate experts. Ken Pecos and the Pecos Group helped me and my family. They can help you. This is Gary Quackenbush of The Word on Wealth. You hear Ken every week here on The Word on Wealth. He's our expert. He's got integrity, exceptional service, deep knowledge of the San Diego, Coronado, and South Bay regions. These are just some of the reasons that Ken Pecos has completed hundreds of transactions. He manages a powerful team of professionals at the Pecos Group. From single-family attached homes to luxury high-value waterfront properties to apartment buildings, Ken Pecos is ready to help you avoid problems and costly mistakes. Learn more online at kenpecos.com. That's Ken Pecos, Pecus.com. Or call 619-977-8419.
DRE number 010566969, brokered by eXp Realty. Looking for something
Tell a friend about this broadcast outreach, The Word on Wealth, with Gary Quackenbush of GQ Law. Call or click to request your free initial consultation or to talk with a member of the team. Call Gary at 855-500-TRUST, GQLaw.com.
You're live.
Right, we've got lines open. You're here listening to The Word on Wealth. This is attorney Gary Quackenbush, 888-344-1170. 888-344-1170. Call up and ask me your question. Be a part of the show. This is cool. Gosh, maybe I'll get excited and give you one of my free books. Who knows? Call us up 888-344-1170 if you've got questions regarding your estate plan, probate, trusts, things like that. All right. If you want me to help you like review your estate plan or to help you be a good successor trustee because maybe a family member has passed away and you've been asked to be their successor trustee and you don't quite know what to do, which means you're normal because nobody knows how to be a successor trustee unless you do it for a living. Nobody knows how to do it. That's kind of the whole problem with being a successor trustee. That's why people mess it up so much. They don't know what they're doing. But judges, quite frankly, are not super forgiving if you don't know what you're doing and you do a bad job. The judges are not super forgiving because they say, well, you agreed to do the job. You were nominated in the trust, but you did the job. So get it done right. But get help. There's a lot of people that are willing to help. Certainly my firm is. And if that's something I could help you with, call me 855-500-TRUST. Okay. Here's the questions. Frequently asked the following. It says, okay, the estate plan, let's just say it's a basic estate plan. It's set up. There's 3 kids, a son and 2 daughters. The son has kids, the daughters don't. And the question is, well, when my son dies, who gets his share? That question makes a difference on when son dies. If your son dies before you, typically your trust will say that the money, his share goes to him or to his issue. Issue is a funny term. It's a legal term that means your bloodline, your lines of consanguinity. So like me personally, I have, what do I have? I've got 12, I've got 16 issue. So my issue are 16 people. My issue consists of 16 people. It's my 4 kids and my 12 grandkids. Those are all my issue. So if I have in my trust and it says when I die, all of my property goes to my children or their issue in equal shares or by right of representation, there's different terms. But if I say that, then that means if I die, we count how many children I have. How many bloodlines are there? There's 1, 2, 3, 4. And we go to the first person in that bloodline and that's where we stop. So if all 4 of my children are alive, they get equal shares, 1, 2, 3, 4. Okay. If one of my children had passed away, let's say my 3rd kid, and he's got 3 children. So now I'm counting bloodlines. I go, okay, Gary and Cheryl died, and we need to go, the property goes to my issue or to my issue, which is my children or their issue. So I count and I go, daughter's alive, son's alive, other son's alive, one son's deceased. Okay, there's 4 bloodlines. So my deceased son's inheritance goes into his bloodline. Now his bloodline, he's dead. So it goes to his issue and he has 3. Got that? So that means each of his kids will get 1/12 of my money. My 3 kids that are alive will each get their 1/4. And then the 1/4 that goes to my child who would be deceased in this example is going to get split 3 ways. 1/4 divided by 3 is 12. 1/12. Okay, that's how things pass by right of representation, meaning that there are 4 representative bloodlines. Okay, now there is another way to do distributions, and that is, don't do this to me, okay? Please, I know people do it, but here's how it goes. It's called per capita. And so per capita means like per head. Just think cap. So if I said that my property goes to my children or their issue per capita, okay, we got to count bloodlines again. No, we got to count living heads. So we go down the first. So we'll do the same thing. My 3rd son, we'll say he's passed away and he has 3 children. Okay, so now we're going to go per capita. So I'm going to count 1, 2, 3 kids are alive. And then there's 1 deceased kid, but he's got 3 heads. 1, 2, 3. So I got 4, 5, 6, right? Living son, living daughter, living son. That's 1, 2, 3. And the deceased son has 3. So that's 4, 5, 6. So everybody in the family would get 1/6. Cool, huh? That's per capita. And most people don't do distributions per capita because it ends up that the surviving children get less and more goes to the person who lost their father. But that's kind of the idea. They go, well, but if when I die, one of my kids has passed away, then they're going to need more money than my surviving kids because my surviving kids still earn money. They don't have a widow or a widower to take care of. And so that's why sometimes you do this per capita thing. Pretty interesting. So if all I said in my trust is when I die, I want my property, all of my property to go to my issue by right of survivorship, then it's going to go to my 4 kids. If one is dead, it's going to go to that share will go to those children. Okay. And if one of those children had died and they had their own children, then their share gets split between their own children. Okay. So that's the distribution. Those are issue. We're counting lines. We're counting lines of consanguinity, which I love that term. Isn't that the coolest thing ever? Bloodlines, lines of consanguinity, issue. And so people always play with me when I use the term issue and they go, issues. So I have 4 issues. I go, I think you may have more than 4 issues because you have 4 children and children are your issue and those issues create a lot of issues. So your issue have issues and your issues give you your issue gives you issues. Okay, we're going to move on. 888-344-1170 is the answer to, or the question, the number to call so you can ask me your questions about. You don't have to ask me about lines of consanguinity or issue. That's okay. Moving on. Okay. Payable on death accounts. They said, what is a payable on death account? How does that work? Here's the scenario. I put money into a bank account and I go to the bank and I say, hey, bank, I want this money in my trust. And the bank says, I know, it's true though. The bank says, oh, you can't put that money in your trust because it's a high yield savings account and it's in treasury bonds and you cannot hold that in your trust. To which I get really annoyed because I'm an estate planning attorney and I want everything in my trust. Sorry, Gary, you can't have that account in your trust because it's an account that is not able to be held titled in the name of a trust. It can be held in your name or you and your wife's name, and it can be a POD. What's a POD? POD is a payable on death account. It's kind of the same thing as a beneficiary. Beneficiaries, just you usually see those on things like life insurance or an IRA or something. But a POD, same thing. It's a pay on death, which means that on this account that I really want to put in my trust with my wife jointly with us in our joint trust, I can move it in myself. It can be my personal bank account. I put in our trust. That's totally legitimate, totally okay. But it has to be a POD. I can't put it in my trust. So POD means my account says, this is Gary's money. And when Gary's dead, it goes to Cheryl. Okay, whatever. It's going to go to her anyway. But what happens if she dies? Well, now you have to have your POD that says primary beneficiary, spouse, Cheryl, secondary beneficiary, 1/4 to Matt, 1/4 to Bree, 1/4 to Ryan, 1/4 to Tyler. That's how I would set it up. But I look at this payable on death account thing and they say, who are your beneficiaries? As many as you want, name them. I went, well, I don't want all my beneficiaries to share equally. I want a primary beneficiary. And if that person is not alive, then I want alternate or secondary beneficiaries. And the account couldn't do it. Well, how annoyed am I? So it's like, okay, forget it. I'm not going to do an account here. I'm going to go somewhere else. I want a different account. Well, they have a regular yield savings, which is earning 3%. Their high yield is earning 5.25% or 5.75%, which is like, that's great. That's better than a lot of stuff in the stock market. But I have to make a decision. Is that going to be a POD? Because that's all they allow. Or am I going to put it somewhere else? So I made the decision. I'm going to put it in a POD account, pays to Cheryl. And if Cheryl's dead, then I'm going to do alternate payees. But that money is not in my trust. What's the problem with that? Because you're saying, well, Gary, so what? You die, it goes to Cheryl. You guys both die, it goes to your kids. That's what you want. True. However, what happens if I'm incapacitated? And now that money is needed to take care of me because I'm in assisted living, sucking down about 10 grand a month. Well, if they need that money, my successor trustee cannot get to it. It's outside of my trust. It is payable on death, not disability. The only way to get into that account is I would have had to have given a power of attorney to my successor trustee person, which I didn't do because I don't like to do that. I gave them instead a limited durable power of attorney. And the limited durable power of attorney says that you can take my financial accounts. If I am incapacitated, you can take my financial accounts and you can move them into my trust. So that means my power of attorney after my incapacity will have to go to this account and say, hey, super high yield savings account. I'm closing that account and I'm putting all that money in Gary's trust. And I'm going to find another account that will allow me to hold it in trust and earn money. So that would be a choice they could make. That's why I use a limited durable power of attorney, not a general. General is too powerful.
2 minutes.
Limited does exactly what I want it to. So that's the POD account. Yes, they allow quick access to funds on your death. They're awesome. And if you don't need that money, you're pretty sure you're not going to need it during incapacity. Pay on death account, TOD, transfer on death account, awesome instruments. They work really quickly. If you are the P on the POD that it pays to you after the person's died, then for you to get the money where you're the designated pay on death beneficiary, all that you need is a death certificate and your ID, and they can go get it. So super fast. And in San Diego, death certificates come in within a week. pretty fast. So to get your money out of a beneficiary or a POD or a TOD account, you can get it really quickly. So that's one of the nice things. So if it's money you don't need for your incapacity or, then you can just go ahead and do it as a POD because it's high yield and it's going to make a lot of money in the meantime until the stock market comes back. I'm putting it in there and it will go to my wife and if not to my kids. So I'm okay with that. I'm not happy it's not in my trust. I'd rather have it in my trust so I can tell all my clients everything's in my trust. But I have to got to make some of these tough decisions. And it's not money that I have to have. It's money that I have safely invested. Kind of allows the investment, but it's better than nothing and it's secure and FDIC insured. All right. Some questions that are coming up. I had a question. Somebody said, here was the question. How do I take back ownership of my home from my children? Really? You really got asked that, Gary? I did. Gary, I gave my home to my children accidentally. I didn't know that I did it. How do I get it back? We're going to talk about that coming up next year on the Word on Wealth. Let me help you do your estate plan. 855-500-TRUST. Please let me help you do your estate plan. Be prepared for the inevitable day. 855-500-TRUST will be back. How to take back your home if you gave it to your kids.
You don't need to know everything. You just need to know where to find answers you can trust when you need them. Welcome to the Word on Wealth with Gary Quackenbush. We are here to help you build, protect, and transfer everything you've worked hard for with expert estate planning, trust administration, inheritance, and probate. Call Gary and the team at gqlaw.com. 855-500-TRUST. Eight five five 500-TRUST, or go online and download Gary's free ebooks and videos. Read Gary's blogs. Call or click to request your free consultation or to talk with a member of the GQ team. That's gqlaw.com. 855-500-TRUST.
You're live.
Right. Got it. 855-500-TRUST. If you need some help from me, if you want to ask me a question, I got lines open. They're going to be open to the top of the hour, so call soon. 888-344-1170. Okay. So the question literally is, how can I take back ownership of my home from my children? And what happened was, let's see, let's go to right there. Yeah. So what happened in this situation was the kids. So the explanation is my wife and I bought a home in trust and my wife passed away. Okay. Then my son took me to the UPS store to sign some papers without clear explanation. I am Korean. I am over 82 years old. I don't speak good English. And he had me sign a couple of things and said, don't worry about it. We're good to go, Dad. I'm just kind of taking care of things like you want. So what he found after he looked into it, somebody helped him. He found that he had signed a document transferring the home to his son. Okay, I know what you're all thinking. You're thinking, you've got to be kidding me. You're making this up. I can't make this stuff up. I mean, that's insane. So, I mean, my reaction to that is the first thing I do is get crazy. I mean, that's crazy. So to get the home back, it's like, well, have you talked to your son about it? Yeah. And he told me, I signed the document. That's too bad. It's his house. So I told him that I didn't know what I was signing and that he tricked me into it and that I don't like him anymore. And he said, you said, you signed it voluntarily. I didn't take you against your free will. The notary was there. You signed it. It's my house. So what do you do now? I mean, you're talking to your kids, not working out. You have other kids, have them go and take care of business with him. But I think in something like that, unfortunately, it's going to be a situation where he probably has to go to probate court and file a petition to reverse the deed that he had signed and basically show that it was signed in error. And then once that's established, you can get a court order or a recorded deed. That's kind of, we call it an oops deed. And the oops deed transfers a house. You're saying, oops, I didn't mean to sign the deed. If you wanted to get the house back and you convinced your son that he was being bad and doing something you didn't want, then you could have him sign a deed transferring it back to you. Problem with that is going to be, now it was a transfer from a parent to a child and now a child to a parent. And they're not going to be an exempt transfer. So usually it's going to be the oops deed. I don't know, stuff like this just stinks, but it happens. He says I transfer the house to my son. It's getting worse. His kids moved in. His wife's in here, and it's getting worse every day. What do I do? And I said, you gotta stick up for your other kids too. And so what happened is other kids got involved, very aggressively involved, and got everything reversed. But what a jerk. Yeah, what a jerk. Next question was, where should a family start the probate process?
Well, that's an interesting question, Gary. I'm just asking from an outsider, somebody maybe that's never been through it. Is there a specific point that you said, yes, this is where you start the process, or are there a couple of different ways in going about it?
With probate, what we're trying to get accomplished is we're trying to change the title from the deceased person to whoever's supposed to get it, whoever's the beneficiary. And so the probate process, you can start it really quickly. If somebody passed away and you realize, oops, there's no will, there's no trust, the house is deeded directly in his name, you can file a probate petition right away. And so timing wise, it can be done very quickly. It's a very slow process. So I always try to get it done sooner rather than later. And then as far as where, the question really comes up is, where does the person own their property? So if it's San Diego County real property, then you could file a probate in San Diego County. If the guy, lived in San Diego County and then he moved in with his daughter up in LA County and passed away, then you could do the probate in LA or San Diego, because the property is here, LA, because that's where he was living for a while and passed away. But typically we would want to do it where the property is, because that's where we're going to, that's where you would get the attorney and you would go to that court. And it's because the property is here. It's just kind of, there's a lot easier interactions, and you don't have to always do probate where the person passed away. So the question in this that was posed to me on this was, they were trying to figure out what to do because they couldn't find a will. And their dad had told them, I left a will. It's all, and not dad. It's like an uncle, family member is all they said. So the family member basically promised them that he left a will and everything was taken care of, and they couldn't find a will. They tried pulling up the carpeting. They tried looking in banging on the walls, looking for a safe, looking for anything to establish that the guy had a trust or a will or anything, and couldn't find anything at all. So unfortunately, he had to go through probate. But that was a good question on where to get it started. Okay. Next question. If you got one, call me 888-344-1170 and let's go over your question. Okay. The question here is, if my husband and I are listed on the deed, but he puts his daughter in the trust, will she get the house? Okay, so what she's concerned about is her husband inherited money, bought a house. Okay, they bought a house and they put both of their names on the house, which that's very nice of him. Not necessarily, but he did it. And then he wants to only put his daughter on the living trust. And she wants to know, the wife wants to know, when my husband dies, am I going to have to move out of the house? And the answer is no. Okay. The putting the daughter in the trust, basically saying, when as long as it's a joint trust, because it's a joint house. If it's a joint house, the husband can't give away the whole house, because the deed, a joint deed, is going to say when husband dies, the wife owns the property, unless they did tenants in common, which nobody does. So if they bought this house together, even though it was using husband's inheritance, it's titled together. That's what controls. So husband dies, title then slides over 100% to wife. So at that point, it doesn't matter if the daughter's in the trust. Wife has the house solely. And typically in a trust, it doesn't become effective to give the daughter any money or any property until both of the creators of the trust are dead. So it could totally happen that the daughter doesn't get anything. Well, wouldn't get anything for sure until the wife died. Once the wife died, then daughter would get her share out of the trust, which would probably be the whole thing. So that was a good question. And if it's in trust and the house was originally in joint tenants with your husband before it got put in the trust, you don't have to worry, because that house is your joint asset. And the trust is just going to direct what happens after you have both died. And next, you're going to ask me, can you modify the trust? And that's a conversation we can have offline. Typically, it depends on what the trust says. It may be that you cannot amend the trust at all after your husband died. It may be that you can modify parts of it, but you're probably not going to be able to touch the distribution on how you're giving money away. So those are there's some tougher things that you got to think about and revisit. And my suggestion is revisit your estate plan at least every 3 to 5 years to make sure it does what you want it to do. Call me and I can do it. 855-500-TRUST. Can an ongoing, this is a good one. Can an ongoing business be transferred to a trust? This is one of my, pet peeves, one of my favorite things to do. So if you have a business, so let's say you have a small business and it's a construction company, and you think, I want to put I want to transfer my ongoing business. Can my trust run the business?
2 minutes.
Can it own it? Remember, it's always the successor trustee or the trustee who's really doing the running of the business. It's the trustee owns it, not the trust itself. So the ongoing business, easiest way to put it in a trust, easy peasy, incorporate, or LLC. But let's say you incorporate, which is a good idea anyway, because you got some tax savings, you got some liability checks that are going to be really important to have, especially in this society where we like to sue each other for everything you can imagine. So you put it in a corporation, and then you issue the shares of the stock first to you and then next to your trust. So you issue them to you, and then you agree that the stock should have been issued to the corporation. So it's a 2-step process. But ultimately, if I look on your stock ledger and if I look on your stock certificate, it's going to say the business is owned by the stock is owned by the living trust, the trustee of that living trust. So that's how you transfer business. But the trust, as the owner of the corporation, ongoing business, fine, do its thing. But I like corporations anyway. Okay. Now, I've got a couple other questions coming up. Let's see. Yeah. Oh, yeah. Good one. Okay. Coming up, I want to talk about what if I didn't put my house in the trust, or my house is out of the trust, but it's listed on Schedule A. So I thought it was in the trust. I just didn't know. What do I do? And there's some procedures. We're going to talk about that. If you get it right, the procedures are fairly quick, like a 3-month process. If you get it wrong, it could be, a year. something like that. So you got to get it right if the property needs to be transferred in trust. We're going to be talking about that coming up next. If you got questions for me, the number is 888-344-1170. On my website, gqlaw.com, there are free books. Living Trust Basics is the most popular. You go on there, you click on it, and you get a PDF of a book called Living Trust Basics on my website, gqlaw.com. We'll be right back.
You've got questions. We've got answers. This is the Word on Wealth with Gary Quackenbush of GQ Law. Gary's here to give you peace of mind with expert estate planning, trust administration, inheritance, and probate. Call Gary to build, protect, and transfer your wealth. 855-500-TRUST. GQlaw.com.
Gary, how do you and your team help our listeners avoid probate?
Well, first of all, probate is a process that involves attorneys, judges, and sometimes contesting parties. And so we try to avoid probate at pretty much all costs. The way we do that is setting up living trusts, setting up properly documented wills, putting the property like houses, cars, bank accounts in that trust so that it avoids probate. Probate is only necessary if the estate plan isn't set up quite right. So we help them get it set up right. And mainly that's done through a properly created living trust.
Call Gary and the team at GQ Law, 855-500-TRUST, or go online and download Gary's free ebooks and videos. Read Gary's blogs. Call or click to request your free initial consultation. That's gqlaw.com, 855-500-TRUST.
It's
Tell a friend about this broadcast outreach, The Word on Wealth, with Gary Quackenbush of GQ Law. Call or click to request your free initial consultation or to talk with a member of the team. Call Gary at 855-500-TRUST. GQ Law.
You're live.
right. Well, that caught me off guard. Hey, that's me right here on the Word on Wealth. Live, local, happy. Good to be along with you. This is Gary Quackenbush on the Word on Wealth. 888-344-1170 is a number you can call and you can be part of the show. We're going to be here right to the top of the hour. So do not wait too long because you're not going to.
And you're mentioning happiness, being happy. Well, tomorrow people are in for a treat because we have Edwin Itabiri, the Chief Happiness Officer, joining us.
Oh, so cool. I can't believe we got him back again. I'm always blown away when he comes on because I'm just like, oh my gosh, we're done these regular people and he's a big deal. And Edwin is just so fun. I like talking to him because I have to listen really carefully. He's got that insane accent, which I totally love, but he is just so kind. And yeah, that's Friday. So Friday's show, Finding Joy Friday, right here on the Word on Wealth. You're going to tune in same time, same station on Fridays. And you're going to have Finding Joy Friday with Edwin Itabiri, which is going to be super cool. You're going to love it. The next Friday, we got that set up. We're going to have Darcy Feekway again. We got the show set up, man. Next week's going to be right on. We're going to have a good time. I want to, the other thing I want to go over is the question, the thing that came up. Okay. It is as follows. My property is listed in my living trust, but the title never got put in the trust name. How do we transfer it into the trust? Okay. You just create a deed. That's easy. So the scenario is if you are still alive and competent and it hasn't been transferred to the trust, you do a deed. What I typically do is called a quit claim deed. Not quick like fast, but quit like I give up. So quit claim deed transfers the property from you to yourself as the trustee of your living trust. Do it done. Do it. Get it done. Get it done ASAP. You can call me 855-500-TRUST. We do that kind of stuff all the time. If, however, the person that is talking to me and asking the question is the child beneficiary, and now parents are both dead, and they say, my mom and dad had a trust. They set it up years ago. And I know it was their intention to put the house in the trust because it's listed on a schedule, but they passed away and the house is still in their name. What do I do? There's two things. One is we can do a thing called a Hegstead petition, which is a short probate process that only takes about 3 months, as we can do a process where we go to the probate court and say, look, judge, this is supposed to be in the trust. Here's a copy of the trust. Here's a copy of the schedule that lists the house, saying all my property is, including my house, is in my trust. And so it was just a mistake, and we want an order. So we get an order from the court that says the house belongs to the trustee of the trust, called a Hegstead petition. If you don't do that, you can create a quitclaim deed. It's just not going to be valid. You can create deeds all day long, but you have to have it so where it actually transfers the property in a valid method. It's going to have to go through probate court in a Hegstead petition. So if you need help with the Hegstead, 855-500-TRUST. We got you. Got you covered. All right. Here's one of the craziest questions that I've ever had asked to me. Somebody really wanted to know this. Can a person who is at end stage of ALS and cannot move, can he sign a trust if I put his hand on the page and I move his hand around? And so the way this scenario came up, it was dad passed away without a will. And brother-in-law said that they get the money because there was a will. Well, the will was drafted when dad was super sick, couldn't even move his hand, and somebody drug his hand across the page and said that's his signature. Dude, that doesn't work. What are the witnesses going to say? Yeah, he was of sound mind. He knew what he was talking about. He understood what property he had. I understood his testamentary intent. We know, I know this is what he wanted. You got to have witnesses, disinterested, non-family, non-listed in the will people say that this is exactly what the guy wanted. And that's really, really tough. I don't, moving somebody else's hand to make them sign a piece of paper. I mean, it's better to put his pen in the right spot and let him move it around as a scribble. That's better than trying to move it. If you move it yourself, then that's an involuntary signature. Don't do that. Bad idea. Bad idea. Bad idea. Okay. Couple of things I want you to know is when should you review your trust? Good question. I think if your trust if it's 5 years old, you need to review it. If it was created before 2015, you may need to redo it, not just review it. I've had quite a few people that have come in with trust lately that were created by their attorney, law firm, whatever. The firm doesn't exist anymore. The attorney doesn't exist anymore. And so now they're trying to figure out what to do, what to change. And sometimes we just amend them by changing. I can take, some other attorney's trust and amend it or fix it. We do that quite often. If you have a do-it-yourself trust and now you're going, you know what, I need to really get it done right. Come in, bring your DIY trust. Let me take a look at it and I'll tell you what needs to be done. And don't be surprised if it's a 10-year-old DIY trust, if I'm going to tell you that you need to just start over and get everything taken care of, get under all the rules and guidelines you're supposed to, but just get it done. Okay. Now, the next thing I really want you to understand is a living trust and some of the terminology. When I was talking to a client a couple of days ago, we were running into the issue of the trustee. So that when you're putting money in a trust, the deed doesn't say Gary transfers his house to Gary's trust because the trust can't own anything. So if you look at the title to your house, you look at the deed and it says that you transferred it to your trust, it's not even valid transfer. We're gonna have to go to probate court to get it straightened out. So instead of that, get a deed prepared and get a deed that does it right. It doesn't matter that the old one is bad, just do the right one. So that way everything is in the trust and you don't have to go through probate and probate court orders and leave your kids in a lurch. So that's the deal with that. The next thing is when you the question was regarding like what happens if my trustee says that she owns all the property and she runs away with it. Now the scenario is a sister became the successor trustee and she just lived in the house for 10 years. Okay. Their other siblings came to see me and said, this doesn't seem right. Dad died 10 years ago. Mom died before that. And now we have sister living in the house and she says it's her house. Well, we end up talking to sister who says it's my house and I'll prove it. She sent a copy of the trust and she sent a copy of the deed. And sure enough, the deed, the trust says in there that the house goes to all the kids. So all three. But then the successor trustee points out, and she says, no, it says right here on this deed that mom and dad transferred the house to the trustee of their trust. And that's me. And they knew I was the trustee of the trust. So this house belongs to me. So good luck figuring that one out. I don't know why she thought just because she was the trustee, if things are titled in her name, it's hers. It's hers, yes, as the trustee. But if it's yours as a trustee in the capacity as trustee, then you have to do what's right. You have to do what the trust says is. You don't make this stuff up. You just don't. It's like me going to my financial advisor and saying, hey, I'm going to transfer all this money to you. Here's $100,000 to invest for me. And so I write him a check and I hand it to him and he goes, oh, thank you very much. And he puts it in his own bank account. No, you're investing it for me. That's the same thing with the trustee. The trustee's job is to take care of the property on behalf of the beneficiaries in the best interest of the beneficiaries, according to the terms of the trust, not their own terms, not what they want, but according to the terms of their trust. All right, you guys, that's it for today. We have about another minute. If you want to give me a call, it's too late. But I want you to know that we have a podcast, and the podcast is this show. Noah converts the radio sound into a podcast so that you can listen to these shows again. So if you're wondering,
just check it out in the next half hour. It'll be up.
In the next, Noah is super fast. And that is if I'm fast enough to get an email to him, or else he posts it up without my picture. Bum. But no, within the next half hour, it's going to be posted, and you can find it on the KCBQ KPRZ website. You can also find it on Pod or iTunes. You can find it on Google Podcasts. You can find it in Spotify. So it's available. I just want you guys to know that. Or you can also go to YouTube, find my channel. It's just Gary Quackenbush. You can find my channel under GQ Law, and it has all these videos, 154 videos, radio shows telling you about all kinds of things, how to be a good trustee, how to be a good person. Finding Joy Fridays are recorded also. So remember, you guys, come back tomorrow. Tomorrow is Finding Joy Friday with Edwin Edabiri. Super awesome guy. He's the CEO of Happiness, and he talks all about happiness and being happy. And I'm going to ask him some questions about why is it important to be happy? I know you're probably thinking, Gary, that's a dumb question. That's a great question, because the way he's going to answer it, we will see coming up on the Word on Wealth tomorrow. That's on our Friday show, Finding Joy Friday with Edwin Edabiri. Of course, Noah will be here watching things and making sure everything's great. I hope you guys have a great rest of your day. I'll talk to you tomorrow, and we'll see what's up next week right here on the Word on Wealth. Thanks, everybody. 855-500-TRUST, GQLaw.com. Talk to you tomorrow.
Tell a friend about the Word on Wealth, featured since 1995. with financial solutions attorney Gary Quackenbush, an expert in estate planning, wills and trusts, and tax problem solving. Gary is past president of the California Society of Tax Consultants. Reach out to us. The Word on Wealth team of financial experts is here to answer your questions and help preserve your family's financial future. The information you hear on The Word on Wealth is for general information purposes only. This program discusses general financial and legal topics. Seek legal advice from a competent lawyer for your individual legal needs. The opinion